Hi everyone, good afternoon and a very warm welcome to Thorough Newspaper Analysis. Today is 20th of May and this is the video for the day. So without further ado, let's have a look at the pointers of discussion for today. First, we start with the editorial segment. And here today we have a very detailed oriented sort of an article to discuss. This is taken from Indian Express and it carries the title, Why Supreme Court Allowed a Review of its 2022 Judgment on Shamlat Day Land Rights. We'll understand what is the concept of Shamlat Day land. We'll get into some technical aspects of it. We'll understand some land scheme. We'll also understand a couple of aspects related to it. But foremost, what is the core of today's discussion would be the power of review of the Supreme Court. We'll understand how a division bench of the Supreme Court did not take into consideration a constitution bench judgment earlier, and as a result, the verdict wherein the 5-judge bench constitution verdict was not considered is now being reviewed by the Supreme Court. Secondly, we talk about the news updates, and this is going to be followed by the last segment of legal news. So without further ado, let's start with the article, and let's first have a look at the concept of what is a Shamlat Day land. See, this is essentially a village common land which is created by multiple landowners contributing an equal portion of their land holdings to share or serve the common purpose of the village people. So suppose there is a village with 15 villagers. Out of these 15 villagers, let's say 4 do not have land at all, and there are 11 or 12 of them which are, having a certain land capacity holding. So therefore, what do they decide is that we're going to give up a certain portion of our lands equally to create a common land parcel, which is going to be used for common purposes for the village people. So then that is called the Shamlat Day land. Now here, please understand what has happened. Please pay attention to understand the trail of events here. See, there is an act by the name of Punjab Village Common Lands Regulation Act of 1961. Followed. Now there was an amendment which was brought about in this act in the year 1992. This amendment did not set really well with the landowners of Haryana, and therefore they challenged this particular verdict in the case of Jai Singh versus State of Punjab in 2003 before the Punjab and Haryana High Court. So what has happened? There is Punjab Act. For this, we are shortly calling it the Punjab Act. An amendment was brought about in this act in the year 1992. This amendment did not set well with the villagers, the landowners, and as a result, they challenged it before the Punjab and Haryana High Court in the case of Jai Singh versus State of Haryana, I'm sorry. Now here, the Punjab and Haryana High Court relied on an earlier judgment of the Supreme Court, which is called Bhagat Ram. This is a 5-judge constitution bench verdict. So Punjab and Haryana High Court relied on it and gave a certain verdict. Now the aggrieved persons, they approached the Supreme Court, and in the year 2022, the Supreme Court overruled the judgment of the Punjab and Haryana High Court. But interestingly, the Supreme Court did not at all consider the case of Bhagat Ram versus State of Punjab while giving its verdict in the case of 2022. So now, therefore, on the ground that an earlier constitution bench verdict of the Supreme Court was not considered by a division bench of the Supreme Court when it delivered the 2022 verdict, now this particular judgment is being reviewed in another case of Karnail Singh versus State of Haryana. So this is a very important facet because the judgment is reviewed on the ground that there was an error which was manifest on the face of the order, and therefore it should be reviewed. And here the Supreme Court made some pertinent observations about how this was not correct on part of the division bench in the year 2022 to ignore a constitution bench verdict. And more so when the High Court did that. When the High Court relied on the constitution bench judgment, then at least the Supreme Court should have looked into the reliance that the High Court placed and should have furnished the reasons why the High Court's reliance was not deemed appropriate by the Supreme Court. So since we've understood the core and crux of it all, now let's get into the technicalities of it. So protecting the rights of the village owners in Haryana, village landowners in Haryana, the Supreme Court allowed a review of 2022 judgment where a bench of Justices Hemant Gupta and V. Ramasubramanian allowed Gram Panchayats to acquire Shamlat Day lands. What is this that we've already understood? We've already understood the amendment of 1992. Now let's see what was this amendment. See, it essentially allowed Gram Panchayats to manage and control shamlat land as land reserved for common purposes of village. So as we understood, these are essentially the lands which are contributed by, which are, lands parcels given up by the villagers, and they formed a common parcel which is used for the common purposes of the entire village. Now, by virtue of this amendment, the control of this land parcel is given to the panchayats, and the panchayats are now supposed to, control and manage these parcels of land for the common purpose of the village only. So what has happened essentially is that the control has been shifted in the hands of panchayat, and therefore the landowners were feeling aggrieved. Now here we have to look into the case of Bhagat Ram versus State of Punjab, because this is the case of 5-judge bench which was ignored by the Supreme Court in the year 2022. So for understanding this case, we have to get into its facts. So please understand, in the year 1967, there was a scheme by the name of consolidation, land consolidation scheme. What was the content of this land? What did it do? It essentially proposed to reserve land for common purposes and divert the income of these lands to the panchayat. So the land consolidation scheme required that land be reserved for common purposes of the villagers, and whatever income is derived from that land, it be given and handed over to the panchayat. Now, naturally, the landowners, they felt aggrieved and they challenged the scheme with the argument that it violates the second proviso of Article 31A. So what is Article 31A second proviso? It essentially tells the government that you cannot acquire a land of a person which is less in size than the ceiling limit. And if you do so, if let's say the ceiling limit is X amount, portion of bigas or whatever portion of land, and if you're acquiring that land which is in lesser size than the ceiling limit, then you have to pay compensation to the person, and that compensation should not be less than the market value for the land. And the villagers, the landowners were saying that the reserving of these lands for common purposes and diverting all the income to the panchayat, it violated the second proviso of Article 31A, because they were not compensated. But on the other hand, the High Court, the state of Punjab argued that reserving land for the income of the panchayat, it is not equivalent to acquiring the land. Why? Because this income, it would eventually be used for the benefit of the village community. Now, please understand, when the Supreme Court was delivering the case of Bhagat Ram versus State of Punjab, on the very same day, the Supreme Court delivered another judgment in the case of Ajit Singh versus State of Punjab. So what was held in this case? In this case, the Supreme Court carved out difference between land being acquired by the state and the modification or the extinguishment of land rights under Article 31A. Here, the Supreme Court said that when the land is acquired, the state is the beneficiary, which is not the case when the land rights are modified or they are extinguished. Applying this logic in Bhagat Ram, the Supreme Court in the case of Bhagat Ram held that the beneficiary of the land consolidation scheme was the panchayat and thus also the state. The court held that the panchayat was also observed. The court also observed that the panchayat was effectively acquiring the land by reserving its income, and that the panchayat's income can only be used for the village community's benefit. Thus, accepting state's argument would defeat the object of the second proviso. The state of Punjab also argued that even if the land was being acquired, because here firstly they argued that this reserving the land and diverting the income is not equivalent to acquiring the land. But then the Supreme Court said, even if, let's say, for the sake of argument, it is equivalent to acquiring the land, then also Article 31A would not be applicable because this was introduced later on. However, the Supreme Court noted that the possession and control of the land, it was not transferred as the scheme had been stayed by the Punjab and Haryana High Court. And under Section 24 of the Consolidation Act, the scheme will only be deemed to have come into effect after possession is transferred. But here the possession could not be transferred because the scheme was stayed by the High Court. Now let's understand the main judgment of the High Court, wherein High Court placed reliance on the case of Bhagat Ram and the Supreme Court did not rely it. So in 2003, the full Judge Bench of the Punjab and Haryana High Court decided the challenge to the 1992 amendment, and here the High Court gave partial relief to the petitioners by distinguishing between land that has been reserved for common purposes under the Consolidation Act and land which has been contributed by individual proprietors but is not reserved for common purpose. So the High Court held that the control over land contributed not part of consolidation scheme. It could not vest with the panchayat as part of the consolidation scheme. Relying on the Supreme Court decision in Bhagat Ram, the High Court held that the state and the Gram Panchayat could not acquire land that is not reserved under the consolidation scheme without providing the compensation. The state of Haryana therefore challenged. Now, this was a pro-landowner verdict, and the state of Haryana therefore challenged the decision in the Supreme Court, where the Supreme Court decided this matter in the year 2022 without considering the case of Bhagat Ram. The bench overruled the 2003 decision, finding that there was no requirement to pay compensation since the amendment to Punjab Act, it was passed, the 1992 amendment, it was passed after the Article 31, it was omitted following the 44th Amendment Act in the year 1978. The bench, it also held that the management and control of the land was vested in the panchayat the moment it was assigned as a first step before executing the consolidation scheme. So therefore, for our purposes, what we need to understand is this is important for judiciary purposes. So the bench in the current 2024 decision said that, or found that the 2022 verdict, it only made a cursory reference to the Constitution Bench decision in Bhagat Ram, and as the 2003 High Court judgment that was being appealed against heavily relied on the case of Bhagat Ram. This we've already discussed, that the 2003 verdict, High Court heavily relied on Bhagat Singh. So therefore, in the current 2024 verdict, the Supreme Court said categorically that since the High Court has itself made reference to Bhagat Ram, so therefore, what was expected out of the Supreme Court in the year 2020 was at least that it should have given reasons why, it did not agree with the High Court verdict. But on the contrary, instead, there was not even a whisper about the Constitution Bench judgment in Bhagat Ram. The bench in 2024 decision in review held that 2022 decision vesting control of the land in the panchayat once the land is assigned, it was totally contrary to the verdict of Bhagat Ram. And the apex court held that a smaller bench, which is ignoring the Constitution Bench decision, it was material error, which was manifest, absolutely visible on the face of the order, which is a bar that is set for allowing a Supreme Court judgment to be reviewed. Consequently, the bench recalled the 2022 decision and directed the challenge to 2023 High Court decision to be heard later on. So consequently, the bench, what is it done? It has recalled the 2022 decision of the Supreme Court itself, Division Bench, and has directed the challenge to the High Court verdict of 2003 to be heard once again beginning from 7th of August. Now, please understand what we have to remember for our purpose for judiciary exams is the power of the Supreme Court to review its own orders and judgments. So let's locate the provision in law. It is Article 137 of the Indian Constitution. So what is the scope of Article 137? See, it essentially provides that the Supreme Court has power to review its own judgments and orders. And this power is subject to a law which is, let's say, made by the Parliament or to the rules which have been enacted under Article 145. Now, I believe under Article 145 Clause E particularly, there have been some rules which have been made for the purpose of giving effect to the review power of the Supreme Court. And there are certain grounds which have been identified on which a review can be made. And first and foremost ground is this, which is that when there is any error which is, apparent, any mistake which is apparent on the face of the record. So that is one. Secondly, discovery of new and important matters of evidence and any other sufficient reason. So here what has happened is this error in 2022 verdict in not placing reliance and not looking into the Constitution Bench judgment of the Supreme Court in Bhagat Ram, it is an error which is apparent absolutely, manifestly on the face of the order. And now we proceed to the national news category. This is the first update here. Plastic-free river campaign to launch on 5th of June on River Ganga. So the Wildlife Institute of India and the Social Development for Committees Foundation, they've launched a collaborative initiative which is called Flowing Towards a Plastic-Free Future. And the purpose of this collaboration is to free River Ganga and its 15 tributaries from plastic pollution and to conserve the aquatic and terrestrial ecosystem. Second up is this update. NASA appoints new chief for artificial intelligence. NASA, it has given a new role to David Salvagnini as the agency's chief artificial intelligence officer. This role, it is in addition to his current job as the chief data officer. Nandini Dairy, it will sponsor Scotland for T20 World Cup 2024. The management of Scotland cricket team, it unveiled its jersey with the logo of Karnataka's homegrown Nandini Dairy for the upcoming T20 World Cup. The Karnataka Milk Federation that runs the Nandini brand, it is the official sponsor of the Scotland team, and this is the first time that the milk brand, it has gone international. India's Air Force's first LCA Mark 1A fighter aircraft, they are set for July delivery. The Indian Air Force, it is likely to get the delivery of its first Tejas Mk1A aircraft from Hindustan Aeronautics Limited in July of this year. The Tejas Light Combat Aircraft MKA-1, it made its maiden, that is to say its first ever sortie from Hindustan Aeronautics Limited facility in Bangalore. The delivery of 87 jets, it is expected to be completed by the year 2028. Now, this has brought us to the international segment. And first, we have a very important update. Brazil is going to be the host for 2027 Women's World Cup Soccer. 2027 FIFA Women's World Cup, it is to be hosted by Brazil. The event, it showcases Brazil's rich culture and love for football. FIFA aims to increase women's football popularity globally. Now, let's have a look at Brazil's sporting history, as in, has it hosted any other prestigious events of global relevance in the past? So the answer here is yes. It has hosted the 2024 FIFA Men's World Cup, 2016 Summer Olympics, and now 2027 is the year when it is going to host the FIFA Women's World Cup. Paris Summit on Clean Cooking in Africa, it ends with the $2.2 billion of global pledges. The summit, co-chaired by leaders of Tanzania and Norway and hosted by France President Emmanuel Macron, it also saw the participation of African Development Bank and International Energy Agency. The developments, institutions, and companies, they pledge to finance access to clean cooking solutions in Africa and reduce the collateral health and environmental risks related to harmful cooking methods. The International Energy Agency, it convened a global leaders for clean cooking summit in Paris. Now, this has brought us to the legal news update segment, and the first is a Supreme Court verdict. This pertains to the Hindu Succession Act. Hindu woman can claim full ownership of property under Section 14, subsection 1, only if she possesses it. This is what the Supreme Court has held in the case of Muktlal versus Kailash Chand through Ella's legal representatives and others. Now, at the forefront, let's have a look at Section 14, subsection 1 of the Hindu Succession Act. So it essentially requires the female Hindu to fulfill two conditions if they want to claim full ownership over the Hindu undivided HUF property, Hindu undivided family. What are those two conditions? Firstly, the female Hindu shall be in possession of the property. So first and foremost, you should be in possession of the property over which you are claiming full ownership. Secondly, she has acquired the property by way of inheritance or device or at a partition or in lieu of maintenance or areas of maintenance or by gift or by her skill or exertion, or by purchase or prescription. So there are so many modes of acquisition which have been prescribed here. So either you have gotten it in inheritance, or because of partition, or in lieu of maintenance or arrears of maintenance, or it's by gift deed, or by her skill and exertion, or by purchase or prescription. So the Supreme Court here has held that for Hindu female to claim absolute ownership of an undivided property of the Hindu undivided family, an HUF, she should have been in possession of the property. So possession is an absolute ingredient which has to be shown. Sale of judgment debtor's whole property impermissible when sale of part property can satisfy the decree. So let's say if you sell part of the property of the judgment debtor, and if by selling the part of the property, the amount of decree, the decretal amount, it has been satisfied, it has the potential of being satisfied, then sale of judgment debtor's whole entire property is impermissible. That is the verdict of the Supreme Court. The name of this particular case is Bigchand, son of Dhondiram Mutha, deceased through Elas versus Shamabhai Dhanraj Gugale, deceased through legal representatives. Let's understand the Supreme Court verdict in a bit detail. So the Supreme Court held that during the execution proceedings, if the attachment of the judgment debtor's property takes place, then the executing courts shouldn't order the sale of whole property when the property, part of it could have satisfied the decree. So if let's say in execution proceedings, the judgment debtor's property was attached, and then if the part of the property is sufficient for decretal amount, then the whole of the property should not be sold. So this has brought us to an end of TNA. Thank you so much for watching. Have a wonderful day ahead.